Hi, and welcome everyone to the CITI Network event on intellectual property and patents. I'm Sarah Williams. I'm a GP by background and recently joined the team here at CITI as a clinical fellow in innovation to Nadine Hachacharam, who's the Director of Innovation and Strategic Partnerships. Some of you may have joined us for the first in our series last month, but for those who are joining for the first time, I'll just give a quick introduction to CITI. CITI is the Centre for Innovation, Transformation and Improvement here at GSTT. It's headed up by Lawrence Talon, the Deputy CEO. And CITI is all about facilitating change and making ideas happen in the trust. One of the ways that we want to do that is through developing a network of change makers, people like you all who are passionate about making things better for our patients. So today's event is as much about us getting to know you, and we hope that these events will inspire you, enable you, connect you with the right people who can help you in your journey for making your ideas into reality. We know there are loads of staff here at GSTT who have amazing insight into ways we can improve care for our patients, whether through improvements to existing care, a change in service, or a new idea for a product. We don't want those ideas to get lost because people don't know where to go with them. So we're here to empower you and help you navigate through those barriers. We also know, and I can speak from experience on this one, that sometimes it can feel isolating to be pushing for change. And so we want this to be a platform for you to connect with other people who can join forces with and share ideas with and work with. But we also want to be able to provide technical skills and knowledge, and we're well able to do that here at CITI because we've got a whole host of experts in various different fields. We had a series back in autumn on artificial intelligence, which you can find on the YouTube channel and is well worth a watch. But today's topic is the second in our series on intellectual property, a topic that has been completely new for me coming really as a clinician into CITI and has been super interesting and important for me to know. I hadn't completely appreciated before the importance of it, but now I can see that knowing a bit, even a little bit about intellectual property is super valuable for innovation. And I'd actually love to see more healthcare staff understanding more about it. So I'm really glad we're talking about it today. Having knowledge of it early on when you have an idea can make things so much easier further down the line. And so it's good to get that knowledge from the people who know so much more about it. So as I said, today is the second in our series, and Tas Gohir, our Senior IP and Commercial Research Manager, is joined by Jamie McDougall, Patent Director and Attorney for Venner Shipley, and they'll be the ones talking about everything you need to know about getting your ideas protected through a patent. So you're all very welcome. I really hope you enjoy the talk and find it useful, and will join us for our future events, which you'll be able to find on our website. Over to you, Tas.
Thank you, Sarah. Thank you for that introduction. As Sarah mentioned, my name is Tas Gohir, and I'm the Senior IP and Commercial Research Manager here at Guy's and St Thomas's. Welcome to the second of these three talks on IP. The first, a few weeks ago, reviewed important considerations for IP arising from the Trust Clinical Research Base, and I gave an overview of IP. Today we'll focus specifically on patents, and I have the real pleasure this evening of being joined by Jamie McDougall, who's a patent attorney at Venner Shipley, who has very kindly given his time to be with us today. Jamie, welcome. Be great if you could just give a little bit of a background on yourself, please. That'd be very, very useful.
Yes. Good evening, everyone. My name is Jamie McDougall. I'm a patent attorney working in private practice for Venner Shipley, and been working with Tas in recent months on a number of patent applications. My background is in physics. I studied at Imperial before joining Venner Shipley 14 years ago today, and I'm now working in their Guildford office, and done work for a lot of different academic institutions. So we're used to guiding the process from research through patenting. I'm in the electronics and software department, and I've developed an interest and expertise in medical devices, methods, and associated digital developments more recently in healthcare. I'll leave it there for now.
That's great. No, thank you, Jamie, and thanks for all the great work you've been doing with me over the last few months on filing.
You're welcome.
Filing the patents that we have done. For those watching live, please do use the chat function to pose questions, and we will try and answer as many of those questions as we can towards the end. So I'm going to bring up a short presentation. I'll share the screen with you and go through some of the basics of patents and the key facts, and bring in Jamie as part of that discussion. So let me just share my screen. Okay, you should all be able to see that. Just moving on to the agenda. So we are going to consider what is intellectual property, and then specifically patents. I will define some key terms which people who are new to the topic, I think are important for them to sort of know. We'll go through the basics of patents, and towards the end, Jamie has prepared a case study that we can use to illustrate some of the issues that we're going to be discussing today, using a real case study as an example. So the first question, I often when I speak to an audience to talk about IP, I often ask what is intellectual property, and I do get a variety of answers to this, from people thinking that IP is just patents, for example. They'll often get an answer, it's patents, but actually it's a much more wider a wider group of things. So intellectual property, patents is just one type of intellectual property, and it's concerned with what is known as novelty and inventiveness, and we'll come back to what that means. The other types, copyright, trademarks, design rights, design rights, database rights, trademarks, and know-how are also all forms of intellectual property that we need to know about as inventors and innovators. In terms of a definition of intellectual property, I often define it as, there's a broad range of definitions. It's a product of your intellectual endeavor. It's a manifestation of ideas, creativity, and invention being put into a tangible form. And I just want to sort of bring Jamie into the presentation here as well, into the discussion. Would you add anything more to those two definitions, Jamie?
I think that's accurate. You do have to make it tangible. You have to write it down or depict it, and the idea being that it should be a protectable asset, as you've said, in a very similar way to an item which you might own. So it's yours if you've created it, to do with it as you wish, to buy and sell. You can also take loans against them. You can license them to others to use, or you can just hold it defensively and use it yourself. So they do a range of things, but the idea is that they should be an asset like any other.
Yeah, sure. So it's a protectable asset, as Jamie has mentioned, just like any other physical asset. Some types of IP can be registered, others are not. And I put the terms background and foreground IP just to differentiate between the two for those that are not familiar. So going into a new project, your background IP is the IP that exists before you start a new project, and your foreground IP is the IP that's created during the project, and maybe the IP that you want to protect by way of a patent. I also want to just describe the difference between inventive and non-inventive contributions, because they are relevant to discussions of intellectual property. Inventive contributions are those that are based on the intellectual input of the inventor and actually result in the actual IP that is protectable. But in undertaking any project, the outcomes and the results of that project and the IP that's created are often dependent on non-inventive contributions as well. it may be financial support, it may be access to facilities, etc. They're all relevant to the creation and completion of a project and creation of IP. And when undertaking, for example, licensing agreements, both inventive and non-inventive contributions, I would say, need to be taken into account in say, for example, revenue share at the end if something's patented and commercialized. So that's a broad view of what intellectual property is. Focusing specifically on patents, there are monopoly rights in any invention, monopoly given by the government, and in exchange for that monopoly, you do have to provide full disclosure of your invention. Patents protect technical aspects of inventions only. And one thing I would say is that you don't always have to know how something works for it to be patentable. You just have to know that it works. And a very simple example of that is you may have a novel therapy. You don't need to necessarily know the mechanism of how it works within the body, but the fact that it works is a patentable aspect of that drug. So who are considered inventors? I think that's also an important aspect when looking at filing new patents. It is very important to get the inventors right, and it's very different from an academic paper where it's easier to put people who may not necessarily have contributed intellectually onto a paper, but on a patent, it is very important to get the inventors right, who actually made the intellectual contribution, and only include those individuals on a patent. Otherwise, it is possible to get a patent disqualified at a later stage if it is challenged. I also just wanted to just explain the difference for those who are not aware, the difference between an applicant and inventor. The inventor is obvious, that is the person who's come up with the new idea. They're an inventor and are stated as an inventor on the application. The applicant would be the organization, for example, they work for, who decided to file the patent. So in the case of the trust, it would be GSTT that would file the patent. They would be the applicant, and the inventors would be stated specifically on that patent filing. The other thing to highlight is that patents are territorial rights. So territories, for example, could be Europe, the US, and other countries. So they are sort of granted at an individual territory level, country level, wide. Now there will be in Europe a single European patent. Most likely early next year. That is still progressing, but currently it is individual countries that grant patents. Also, to just mention, patents are not affected by Brexit, the outcomes of Brexit. The European Patent Office, which governs the patenting framework within the territory, is an international institution, and so how patents are managed and granted, etc., are not governed or affected by Brexit. They're a grant for 20 years, a monopoly right for 20 years, and for pharmaceuticals it is possible to get an additional 5 years. And that's a recognition of the fact that a lot more investment can go into the development of pharmaceutical compared to even medical devices in some cases. So pharmaceuticals are very expensive to develop, and to recognise you can get an extra 5 years. Patents are also what is known as a negative right. So that's a difficult concept sometimes if you're new to this area to fully appreciate. So when you have a patent granted, you don't automatically have a right to do anything with that patent except to stop someone else using your invention. That's what a negative right is. And effectively, it's about making sure what is known as freedom to operate, that you have freedom to operate with your patent. So when you start using your patent, you must make sure that you don't infringe anyone else's IP. So a very, very simple example of that would be if you're developing drug A, drug A, and it's made up of two ingredients, B and C, you need to make sure that you have the rights to use the ingredients B and C to make your drug A. That's a very, very simple example. I was just wondering, Jamie, you might want to mention a couple of real examples, one or two examples of your own, just to illustrate that point, because it is an important concept, this freedom to operate, and important to understand.
Yes, I mean, that was a biosciences example you gave there. I'm on the physical sciences side, and you know, when we're training as attorneys, the example they often give would be internal combustion engine. So someone invents internal combustion engine and patents it. You see this disclosure, you go away and invent a much improved, say, cylinder for it, and you patent that, and you're granted a right for that. You can't then go away and make an internal combustion engine with your improved cylinder without the permission of the original owner of the first patent. You know, you are not free to operate your improvement. At the same time, the original creator of the engine isn't free to use your improved cylinder either. And in this situation, often the result might be a cross-licensing. So you agree with each other that we'll both be allowed to use the improved cylinder, and this allows the development to move forward.
Yeah, that's a great example. Thank you, Jamie. And the concept of cross-licensing is important here. And to get those rights, you may have to pay for those for getting the license that you want to operate your patent. Just moving on to patentability criteria. These are obviously key with a new invention. These are the things that a new disclosure must meet to be patentable. So the first thing, that it must be novel, and what is meant by that is not previously cited anywhere else in the world, in any of the literature, presentations, exhibitions, anywhere, to make it novel. And that obviously requires prior art searching to try and confirm that as much as possible. I would say novelty is relatively easy to demonstrate. The more difficult aspect of patentability is demonstrating that it's inventive. And what is meant by that is it is not obvious to the average person skilled in the art, that particular invention. It's not obvious to the average person skilled in that art. And that's judgmental, which is what makes it difficult. So when we file patents and get examination reports back from various patent offices, most of the objections against granting the patent are around inventiveness. That has been my experience to overcome that. And the average person in this case really is someone that's well versed, knowledgeable in that particular field, not only in the literature which is specific to that area, but also related literature as well. So they have to be a knowledgeable person in that field. Thirdly, it's also very important to keep the invention confidential, not disclosed anywhere before patent filing anywhere in the world. Now, that doesn't mean you can't speak to potential collaborators about your invention. You can put in confidentiality agreements to discuss the information. But in my own sort of personal experience, even under a confidentiality agreement, I would say only give the minimum information the other party needs to know, and only really talk to other parties before patent filing if you really need to. It is always best to file first and then have those discussions, but I appreciate it's not always possible to do that. But confidentiality is really, really key. And the other point to add, confidentiality does include academic papers and of their own papers. So, you know, I certainly came across a couple of examples in sort of this work where an academic published but didn't really appreciate that his own publication was also meant to be a disclosure. So it was also a disclosure, so he couldn't file after that. The patent must also have industrial application. It must be just industrially applicable. Whether that's profit motivated or non-profit, it doesn't matter, but it does need to have an application. Also, there's also the concept of sufficiency of supporting data. When filing a patent, it is important to have sufficient supporting data to demonstrate the invention works. At least lab data, which should show that yes, there is a high probability that this invention works. Now, this need of supporting data is I would say quite critical for the biosciences, less so in the physical sciences, in the sort of things that Jamie does, because there are logic and physical science laws that you can explain something using logic and laws of physics and chemistry, etc., to explain the invention. In bio, it's a bit more complicated, and it is best to have supporting data. I would also say that there is no conflict between patenting and publication. I do get asked this question quite a bit by clinicians and academics, but I want to publish, and I always say to them, look, the two can go in parallel. There is no conflict between wanting to patent and publication. All you have to make sure that the publication is all you need to make sure is the patent is filed at least a day before any publication. I mean, that would be fine. And the two can go hand in hand, and you often can use a draft publication as the basis of a patent filing with the claims, etc., added, so there is no conflict of interest there. I also just wanted to go over the timelines of a patent filing. It is a complex, long, expensive process, and I hope this diagram captures that. So for the inception of an idea, you'll spend some time doing patentability searches, searching and making an assessment of novelty, looking at inventiveness, and at some point you will then, if you go ahead, file what is known as a UK priority application. Now, this is an application obviously in the UK, and the key thing about this filing is the filing date. So from that date onwards, it is a priority, and any similar filings after that date don't matter, because you have priority over anything that is filed after that date by any competitor inventor. After that UK filing, a year can go by when you then have to make a decision within the next year to file a PCT. Now that gives you the ability to file internationally, but importantly based on the original UK filing date. So the filing, that priority filing date doesn't change. You can internationalize the patent of the PCT using the original UK filing date, and that's an important thing to remember. Now, within those 12 months, you can do additional work on your invention and generate more supporting data, which can be included within the PCT application, but it is only supporting data that you can add at that stage. You cannot add any new concepts or potential inventions, but supporting data. After that point, there's an 18-month gap, which isn't actually shown on there, but there's 18 months between the PCT and the national phase filings. At the national phase filings, you have to decide which countries in the world you specifically want the application granted in. And it's usually the countries with the biggest markets, so the US, Europe, Japan, China, etc., Australia. Now, the more countries you have there, the more expensive that filing will be. So just to give you an idea of costs, a UK priority filing will cost between 4,000 and 5,000. A PCT is similar. And at national phase, if you go for the major countries, US, Europe, Japan, China, Australia, those sort of countries, it'll be easily 20,000 at that point, 15 to 20,000, I would say. It is only at that, after the national phase filings within the countries you want the patent granted in, does the patent actually start being assessed by patent attorneys within those countries. So quite a long time has elapsed before anybody even starts examining the patent. And it's at that point where costs can really get very high, because you will then at that point, as the patent application is assessed, you will get examination reports to which you will have to respond with the help of a patent attorney, and that can be quite expensive, overcoming those objections. And at the end of that phase, the patent may be granted, but there is no guarantee it will be. You have to overcome any objections that on each of the examination reports you get, and each country patent office will issue their own examination report. So you will have to respond to each country you filed in and overcome their specific objections. And therefore, the more countries you have, it will be very expensive. And I've known patent filings to go over 80, 100K quite easily, and they may be granted or not at that point. So it is a long, expensive process. And Jamie, I just wondered if there's anything else that you think I may have missed, or that you want to add in describing that timeline at all. It'd be good to get your thoughts on that.
Yeah, I think Tas, you've given them all the information. I think it's not quite as scary as that. I've had some good experiences, particularly in the UK, which is quite a friendly jurisdiction to patent in, and have got grants in sort of a year to 14 months. And I would say that ultimately most patent applications are granted. The sort of percentage of refusal is fairly low, I would say. Ultimately, it depends on the quality of the invention and whether it sort of falls within an exclusion, which I'm sure we'll get onto. But you know, most eventually are granted. And the PCT application that you mentioned is a very useful way of buying yourself more time to acquire the funding that you need. Yes. To file elsewhere in the world. It gives you that 18 months. Can be an invaluable time to both assess where you want to file and to get the funds together as well. So
yeah,
it's a good system, that PCT.
Yeah, it is, and because of the expenses involved, the general principle I've worked with is you must use that time really well after a UK filing, particularly that time between the UK filing and the national phase filings. Those 2.5 years that you have, one to apply for grants and develop your technology, and find licensing partners at that point. And the general rule that I've worked at is that if you get to the national phase filings and you don't have a licensing partner at that stage, then it's worth considering dropping a patent, I would say. Just looking at the overall picture, it certainly does. There is variation in terms of experience, and some territories are easier to get patents in. But overall, it's important to work at getting both developing the technology during those 2.5 years, particularly, and finding a licensing partner or creating a spin-out company, however you want to commercialize that technology. Okay, great. So moving. I'm just trying to move my, the next slide. I've mentioned these costs already, but this is just a quick summary. So initial cost in a UK filing, 4 to 5K, PCT is similar, and then for the reasons I've spoken about, it can increase quite substantially. So in filing a patent, there must be an expectation of significant returns once commercialized, or there is a significant impact. I mean, I certainly have filed patents in the past where the commercial return wasn't significant. There was some, but the impact was very high, and we made the decision to file simply because of that. So that's something worth mentioning too. I also want to just briefly touch upon things which are not patentable in Europe. Now, in the US, it's a little more liberal, and some of these restrictions don't apply. But I think it's worth mentioning these for the European market. The first and important one is, and this does initially sound a little bit odd, but methods of medical treatment and diagnosis are actually not patentable in Europe per se. So in protecting those things which are related to medical treatments and diagnosis, it's really about how you word the claims in the patent. So the wording in the patent mustn't refer directly towards medical treatments and diagnosis as done on the human body. They must be written in a way that doesn't refer to that. So, Jamie, it'd be useful to get your input on that particular one and how you've overcome those that particular issue. I think one of the things is to not write about the final medical treatment step. But it'd be good to get your input on that, please.
Yes, it can be good to not mention some things if your invention is sort of in that field. There's actually 3 exceptions within that. It's a method of therapy, a method of surgery, or a method of diagnosis. So those are the 3 exceptions that are detailed in European law. And the method of diagnosis one is actually the easiest to avoid. Well, I should say that the thinking behind these exceptions is that we don't want to impinge upon the ability of any healthcare professional to go about their business. So we don't want any claim which, you know, a medical professional is going to infringe when treating a patient, so that they're not in danger of being sued or stopped in any way. So the method of diagnosis requires various steps, you know, collection of information, comparison with standard values, and then a final step of actually coming up with a diagnosis, the sort of step that a medical professional might take at the end of the process. So a lot of the time that step really isn't necessary to define your invention if your invention is to do with collating and comparing data to assist a medical professional, but not to actually make the diagnosis. Yes. So, and as for the methods of treatment by therapy and surgery, again, the steps have to be performed on the human body. The claim actually has to say doing this step on the human body, and for surgery, for example, there has to be a significant sort of risk involved in that step. And often, you know, you might have a device which is used therapeutically or used surgically, and you want to cover use of that device. Usually the best way is with an apparatus claim, with a device claim, and you can try a method claim as well. It might be that it doesn't work, particularly if the sort of elements you're using, elements of your system, are already well known and you're just using those in a new way, then you might run into this exception. I've also had the European Patent Office can be overzealous, and you've claimed sort of just the operation of a processor, really, a processor that's in your electronic device, which takes in data and you know, processes it and spits something out, and they've said, you know, the data you're taking in has been acquired via surgery, or it's been acquired via therapy, and therefore the steps in your processor are somehow inextricably linked to what's gone on before or what comes after, and they'll try to bring in the exception that way. So again, it's just about being careful how you word it to make it clear that you're only covering the device and not the operation of the healthcare professional. So.
Yeah.
Well, you're muted, Tas.
Yeah. Okay. Thank you for that, Jamie. Yeah. Thank you for that input. So the other non-patentable things in Europe would be academic discoveries, theories, and mathematical models. But what I would highlight is that algorithms are patentable. And you know, I know we generate quite a few algorithms at GSTT, and we should be looking at the patentability of those where appropriate. Other things are schemes and rules. Now, these are sort of administrative processes, how to organize things. Any inventions around those are not patentable in Europe. Business methods are not either, as well as presentation information are not patentable. Plants and animal varieties which are created through breeding processes for the production of plants and animals are not patentable. So let me just explain that. Let's unpackage that. What I mean by that is that animals and plant varieties which are newly created through normal breeding processes or processes for production of new animals and plants, if normal breeding processes are involved, then those organisms are not patentable. But if they're being created by some sort of genetic manipulation or some sort of human intervention, such as a genetic change, then those organisms are patentable. Yeah, so that's a slight difference. The other thing to mention as well here is an issue known as natural phenomena in the US, which specifically relates originally was brought into this sort of discussion through a diagnostic application. So in the US, there was case law which says that things which are natural phenomena, and by that was meant by something such as a biomarker used for a diagnostic, because they're natural phenomena, they cannot be patented. So that was a case law from a few years ago, which caused quite a lot of discussion within the diagnostic, particularly in the diagnostic industry, where biomarkers and other such things are used for that purpose. And it also meant that it was difficult to get diagnostic patents granted. Now, it did cause a problem. It is still a problem to an extent, but it can be overcome if the patent describes some human intervention which uses that natural phenomena to make a proper diagnosis. So you need to demonstrate some sort of innovative human thinking or human intervention that made use of the biomarker, and that will make it more patentable. So it's not something which can't be overcome or to be worried about too much. There are ways of doing that, again, depending on how you describe the invention and the human intervention that went into using that natural phenomena. Okay, anything you wanted to add on that, on those any of those non-patentable issues, Jamie, at all?
So Tas, I think that the medical device exceptions are the ones that you're most likely to run into. The others are rarer and easier to avoid, I would say. Yes,
it is. Yeah. Okay, great. I just also wanted to just go over a couple of differences between Europe and the US in terms of patent filing. In Europe, the position is that you must file before any disclosure, as I've already mentioned. In the US and a number of other countries, you do have what is known as a 1-year grace period. So if there has been a disclosure of any sort, you do have 1 year after that disclosure to still file in that particular country. And particularly, it's important to know that about the US because it is the biggest market for most things. And if there has accidentally been a disclosure of some sort and you still want to, there's a big enough market opportunity in the US, you can still file a patent within that 1 year grace period. In Europe, it's always been the concept of first to file in Europe. So if there are two competitive inventors who file the same upon the same thing, the patent that will be taken forward is the one that has first to file. The US used to be the first to invent rather than first to file, but they have now changed that back to be more in line with European law. And the final thing there is in Europe, employees own their IP if it relates to the work of their employees. In the US, it is the inventor that owns it and they have to assign to their employer. So the structure of a patent is very similar to a paper. There is an abstract which summarizes the patent, description, claims, figures, materials, supporting data, examples, references. These are very similar to a paper. The key defining aspect of a patent is. And the very last slide, a couple of trends just to mention in the IP space. There will be a single European unitary patent, most likely early next year, still being worked on. And there has been, especially in the AI, I think this is worth mentioning as we have an AI center, there has been a debate in the AI space about ownership of AI inventions, whether something generated, an algorithm, for example, generated by a machine should be owned by the machine or the human inventor that was originally involved. And the recent case study has come on the side of the human, that humans should actually own such an invention. And there's a link on this slide to an article that was written by someone at Venner Shipley who actually worked on that particular case. So I've just put a link on to that. That was all I wanted to say. Jamie, if you could pick up on the case study as well that we have. If I could pass over to you, please.
Of course, yeah. As for the AI issue, that's an interesting one. It was more of a test case, I think. I don't know quite why they did it, but the man, he filed various patent applications with himself as the owner and his AI, who was called Dabus, as the inventor, and said, I was surprised by what Dabus came up with, therefore I cannot be the inventor, it must be Dabus. So he was named, or it was named. But this has been refused both in Europe and in the US. They've stated that an inventor has to be a natural person, which an AI is not, and also that machines can't be employees. They cannot own or transfer any rights, so they lack the legal capacity to be named as inventors. The only issue on this is that as AIs do grow in power and utility and become more widely used, you might want to think about who really does own the invention. If you are using some third-party software, could it possibly be the developer of that software who is considered the inventor, or will it be you as the owner, or will it be whoever's using it, and not necessarily the owner, but an authorized user of the system who's supervising that training? And so there are still some questions as to what's going to happen, and at the moment we feel the best way is to have some sort of contractual arrangements in place that say we'll own the IP from anything that comes out of this AI that we're using.
Great, thank you for that. So Jamie's going to go through a very specific case study, and one to just talk about an interesting patent he has worked on, and also use it just to illustrate in a practical sense some of the points that I've been through just now. So over to you, Jamie.
Great. Can you all see the slides, Tas? Can you see my slides?
I can see them. Yeah, I can see.
That's wonderful. Okay, I'll launch straight into this case study. I've chosen it because I think it's illustrates some of the points that we've gone over in a practical example, and I just find it an interesting case. It was for a spin-out company with inventors who were mainly academics. It's a device, as it says here, for inducing polarization.
Jamie, just a quick. Sorry to interrupt you. If you could go into presenter mode on the slides.
I have done that. Can you not?
Not. Yeah, we can't see that. If you can't, if you can't, then so. No worries if you can't. Don't worry. Carry on.
Is that any better? I'll...
No, don't worry. Do carry on.
Okay. So this basically the human eye has the ability to perceive the polarization of light, which is the direction in which the light is vibrating, and the inventors knew that those who are suffering from any form of macular degeneration, the ability to perceive the polarization is impaired, and so they might be able to use this this fact to do some screening for macular degeneration. And the effect is often referred to as hiding as brushes, and it looks a bit like the image on the far left here, a sort of fuzzy hourglass shape. And in fact, you can maybe able to see it yourself. If you look at a plain white area of your computer screen, you might see a fuzzy yellow area right in the middle of your vision.
Jamie, if I could just say, we were not able to see that particular slide you're referring to.
No.
It's still, yeah, that's it. Yeah. Okay.
Can you see it now?
Yeah, we can see it now. Yeah. Yeah.
Sorry about that. So yeah, the image on the left here, these fuzzy brushes, you may be able to see it yourself as a yellow fuzzy area in the middle of your vision. In fact, if you sort of rotate your head a bit like this, you can get the brushes to rotate as well, because the light coming from a computer screen is polarized. Now, if you have been able to see it, you'll know that it's not that easy to perceive. It's quite small and fuzzy, and also your brain filters it out quite quickly. And so the idea with this invention was to make it more perceivable and quantifiable, at least in a qualitative sense, so that it could be used clinically for early detection of macular degenerative disorder. So the other pictures on this slide show the sort of effect that you can generate. The black and white ring is showing areas of orthogonal polarization of light, and the image on the right is the sort of effect that should produce in a healthy observer, a bit like a sort of magic eye picture, if you remember those. So that was the invention as it was presented to me, and the important considerations that we had at that time. So the first is, when is the right time to be filing a patent application for your invention? As an initial point, I would say that if during the course of your research or work you identify some problem with current methods or devices, and if you feel you've solved that problem or even at least partially alleviated it, then you have the basis of an invention already, which may be patentable.
James, I think you need to move your slides again. It's not moving with. Yeah, I think you'll have to.
I'll leave it on non-presenter then, so that you can see them. And it seems to be not moving on.
Yeah.
While I've got you here, Tas, I mean, I would encourage people to come forward early, I suppose, is the key message, that we're often having early stage discussions with inventors, and there'll often be a patent attorney such as myself involved with those to give a sort of early stage opinion on patentability. And if it is too early, then we'll say so and hopefully give some feedback as to what needs to be done next to move it forwards. But the exception to that might be if publication is imminent or some other disclosure is imminent, which you can't prevent or don't want to prevent. In that case, you would want to get your patent application on file with the information that you had. And that's what I mean by your confidence in the feasibility of implementation, i.e., do you think that the work you've done so far results in a real world implementation which is actually going to work, or when it contacts the real world, are you going to have to make lots of changes, versus the need to file as soon as possible, perhaps for publication reasons, or perhaps just because you're worried about someone else disclosing it, or prior art coming up if you don't get your application on file as soon as possible. As a general rule, in physical sciences, in my field, a proof of concept may be enough. The invention will be based on known laws of nature and logical statements, so you can say with confidence that it will work as we think it will work, and you can then work together with an attorney to come up with some likely implementations, and create a patent application that way. What they call reduction to practice, i.e. you've actually shown a bit more that it works in the real world and has the effects that you say it does, is best if you can get to that stage. That's the gold standard. Additions and changes, as Tas mentioned before, for your initial filing, you can then sometimes add supporting data, which shows that some claim you've already made is effective. You can't add any new material to that filing, but it's normal to have several patent filings, or at least a later patent filing claiming priority. And during that year, we understand that work is ongoing. There may be developments and changes to the invention, and it can be a good idea to include those new ideas and the changes in later patent filings. Although it won't be entitled to the original date, it may still be useful material to include. And just to link that to the case study, the polarization perception device, when they came to me, they already had a prototype. They'd been to a partner with a non-disclosure and got a prototype made, so they already had something to show me, and they'd already had to think about different ways in which it could be implemented in practice. So I had no hesitation for that in sort of saying that they were ready to file a patent straight away, so we went straight ahead with that. The second important consideration is what to include in your patent filing, and the short answer is as much detail as possible. A patent attorney is a patent application is not quite like an academic publication. You can't rely on anything by simply referencing it. You have to actually to spell it out, and so we tend to like to cover all bases and include as much as we can. At the same time, you don't need to go into very much detail about the state of the art and existing systems, and sometimes it can be a bad idea to say too much about what exists already. I would say that some details might not seem worth mentioning to you because they seem trivial or well known in your field, but they probably still are worth mentioning, and mainly for the reason that we don't know what will happen during prosecution of the application. We want to draft an application which is suitable for use all around the world, where they have different patent systems, and you just don't know what seemingly minor detail might turn out to be important somewhere at some point in the future. So as much detail as possible, basically. Supporting data, again, in the biosciences, that is usually essential to show efficacy, and in physical sciences is nice to have if you've got it, because it makes the invention seem well-rounded and convincing, but is not essential if you don't have it. You can just rely on statements that it works. And very important, the last point is to consider alternatives, by which I mean when it's going to be implemented in the real world, are there different ways in which it could be done than the way you're thinking of? Could someone else try and design around certain elements of your device but still achieve the advantages that it has? Future proofing in terms of perhaps technologies which are not mature yet but which might be used, might be good to mention those. And add-ons, by which I mean the sort of larger system around it. Does it display or transmit data somewhere else? Does it interface with a broader system, or are there ancillaries that you would use with it? And it's good to mention those. It might be that they help you a lot during prosecution. So to link that to my case study here, hopefully you can see these two images. The primary design for this polarization perception device is a powered device for use in clinical settings or by an ophthalmologist. So the part on the left here emits light. There are some various filters and layers in between, and the sandwich part on the right is electronically controlled to create patterns of different kinds of polarization and to change those patterns, and to ask, the user what they're seeing. So that was their primary design, but they realized that this, while good, has some limitations in terms of where it can be used and who can use it. So they have an alternative design on the right, which is unpowered. The idea being that you would have the polarization pattern, in this case it's a checkerboard, permanently set in a small object. It could even be a sort of credit card size, and you just need to hold that up to natural light and you would perceive something like the image on the right if you had healthy eyes. So they considered that this was a possible alternative. Is much cheaper, could be mass produced and mass distributed, and so it was important for them to cover sort of both of these and to try to do it with a single patent rather than two patents. And the third important consideration is what to claim. So the claims are the most important part of your patent application. They define the scope of protection, they define the legal monopoly and need to be very carefully worded, and you need to think carefully about what goes in them. And the rest of the patent is sort of there mainly for support and to show implementation details. So a general advice is to go quite broad on your claim. I am still sometimes surprised at what you can get a patent for in terms of breadth. As I say, the UK IPO a particularly friendly jurisdiction. You don't want to go too broad such that you have problems with your search or that you annoy your examiner too much, and you might want to keep it within the context in which you are intending to use it. For example, if it's a medical device, make sure that you clearly limit it to a medical context so that you don't bring in prior art from outside the field, which makes it more difficult to get the case granted. But you can, and usually do, amend your claims during prosecution in response to objections raised by the examiner or to prior art that they cite. There are two types of claim, apparatus and method. So think about whether your invention is primarily a thing, an apparatus, or whether it's a process, or both. It might have elements of both in there. And consider possibly multiple claims if you've got multiple designs. That was what we ended up doing with this case study. We had one claim which was directed to the powered device with a changing polarization field, and we had a separate independent claim which directed to the unpowered device having lots of different areas of different polarization. We also managed to get a third claim which basically had an or statement saying primary design or alternative design, and even a method claim which was essentially just a method of creating and distributing the device rather than operating it. But we managed to get four claims to cover this one invention. So it was a good outcome in the UK for that one. Here is the front page of that patent application, and the last thing I wanted to mention was about ownership and inventorship. So the academics, they got together and they produced a spin-out company, VisI Limited, to be.
Sorry, Jamie, just a very quick. Just to say, we're running short of time, but do cover this slide just a minute.
Yeah, I'll do it quickly. So VisI Limited with the company. The academics, Peter was at Warwick. Gary, he was an ophthalmologist owning his own business, and Brenda was in the Netherlands. And so, there can be issues in terms of inventorship and nationality. For example, if you're resident in France or the US, then there are requirements to file there first. In this case, there wasn't any requirement, and we could file first in the UK. But in terms of who owned the invention, they're all, at least two of them were employed. I think Gary was the owner of his business. In any case, they did the sensible thing and had some confirmatory assignments, if you like, drafted, where they just said whatever rights we have, we assign them all to VISI, and I would encourage you to think at an early stage about who the inventors are, what their contributions are, who you want to own the invention ultimately, and to get some contracts in there at an early stage, just to make things how you eventually want them.
Great. Yeah. Great, thank you. I think that covers. Thank you very much, Jamie. That's really interesting to look at that case study. We are running a little bit short of time. Just wanted to ask Aidan, is there time for any questions? Any particular question? We will try and cover all the questions, get back to people who post questions in the chat. But if there's anything that, if we have time for one or two, that would be great.
Yeah, I think there's time for a couple. So we've got 10 questions coming throughout. So I'll start with questions from Mary, Gavin, and then there's an anonymous one towards the end, and then we'll see how much we answer. So the first one from Mary is, just so I understand, medical research development can't be patented in Europe, but medical devices can.
Could you just repeat that once more? Sorry, I didn't quite catch it all.
So Mary says, just so I can understand, medical research development can't be patented, but in Europe, but medical devices can.
I think the question really is asking clarification on the ability to patent medical treatments and diagnoses. Is that your take on the question as well, Jamie? I think that's what the question is asking.
Yes, I mean,
yes.
The short answer is yes, you can patent medical devices. There's absolutely no problem in patenting a thing. And sometimes you can patent the use of that thing and various methods, provided that they're not going to impinge upon the ability of a medical professional to treat a patient. But it is a grey area, and it's a case by case thing. So I would say discuss it with Tas and me, and we'll talk about what the clever parts of the invention are and whether those parts are going to be excluded, and if not, then that's great, and if they are, then think again.
Yeah, and we'll always find the right wording to be able to protect what we want to. There's no doubt about that. Yeah.
Super. And we've got another question here about Europe. So it says, in Europe, can an individual patent an improved version of IP initially developed at a former employer who did not recognise the value of the idea? I suppose that depends on their contract.
Yes. So certainly certainly in the UK, if your invention is related to your work, and you did it as part of your job, it's automatically owned by your employer. That is the legal position. And so there are situations, of course, where an institution doesn't want to protect the IP and commercialize it, but the employee might. And in those sort of situations, then the organization can agree to give freedom to the employee to assign the IP to the individual concerned for them to then commercialize it in their own right. So there is provision to be able to do that. Yeah, of course. We wouldn't really want to stop anyone commercializing it in that sort of situation. Yeah. I think that covers the question that was being asked. Yeah.
I think so. And I think there's one final one both of you would be great to contribute to. So what are the top 3 things people forget or don't consider when making or wanting to make a patent application?
Well, I could 3 things from my point of view, I guess. They don't consider the market opportunity itself. I mean, I think that's certainly one thing I do have. People coming to me with a great idea, which may be patentable, but they haven't really considered the market opportunity, the need. What I mean by that is, does the market really need that invention? Is it something that if we develop, other people would buy? And I think that's really important, that market opportunity analysis. Also, I would say the routes to market. How are you going to get it to market? Who are you going to partner with to be able to get it to market? Or would you want to create a spin-out company? If you want to create a spin-out company, does the market size justify creating that company? I mean, those two certainly things come to mind. Jamie, do add to those as well.
Yeah, I mean, as you've alluded to, they're not that cheap patents to obtain.
Yeah.
And so you do need a sort of business plan to support them. They are really a business asset. So you need a plan behind it to whatever it's going to be. Even if you're just going to use the invention yourself and stop others, then that's a plan. But you might want to think more about licensing and partners and that kind of thing. Countries of interest as well. A patent's a very strong right. It doesn't just protect use of the invention, it protects its manufacture, and it protects its importation. Even just simply keeping it is an infringement of the patent. So you might want to think about where the device is going to be made, as well as where it's going to be used, and where it's going to be imported to, and that kind of thing, so that you fully consider where you're going to need protection and budget appropriately. Yeah,
those are some things. Well, it's nearly 7:15, or it is 7:15 now. It's time for any more questions, or is it best to conclude, do you think?
I think we've probably got one more question in.
One more, okay, great.
I'm trying to find one which I think most of them have been actually covered or touched on. I think actually this is a good question. Can you give an example of supporting? So this goes back to the timeline for the 12-month period from filing. So what happens if you have developed an iteration you also want to protect? So say you've done some research and you found out that you can tweak your gadget or gizmo to make it better. During that period, what do you do?
Okay, if in that situation, if it sounds to me, if in doing that work, if you come up with a new idea, a new iteration, that is potentially a new invention. If it's considered a new invention, then you would have to file a separate patent application to cover that iteration, the novelty and inventiveness in that iteration. You can't just add it to the original patent filing. The only thing you can add to the original patent filing is supporting data for what you put into that original file. If it's a new invention, you've got to file a new patent filing with a new priority date. Would you agree with that, Jamie? That would be the way to do it.
Broadly, if it really is something different, then you are going to need a new application. If it's an iteration, I think that was the word used. If it's a development on what's gone on before, I think I would err on the side of including it in your 1-year filing, in your PCT filing, and wait to be told by the Patent Office that it's not the same invention, which they will do. You might not be entitled to your original date, but if there's no intervening publication within that year, then you're safe anyway, and you've kept it to one application, which is obviously a lot cheaper and easier to manage. You can also split applications later during prosecution. You can split a patent application out into two if you end up having two inventions in it, and prosecute them in parallel. Keep one, drop the other. There are lots of options during prosecution, so I would get the information in there.
Yeah, that's fair. It's all part of sort of thinking about your patenting strategy and an assessment of how much of a new invention that iteration is, or whether it is close enough to be included. It's all part of that thinking of strategy that we have to, that decision you make at the time. Absolutely great. I guess that's probably all we have time for. We've covered a lot of ground. We've covered why you need a patent, when you should seek one, and what to do what to do in terms of protecting that. I hope we've covered those. And a very big thank you for everybody joining today, and for those watching online. A big thank you to Jamie for joining us and his input and contribution. Really appreciate that. And if you want to learn more about learn more, have more questions we haven't covered today, do email us on citi@gstt.nhs.uk. And we look forward to welcoming you to our next event, which is towards the end of the month, towards the end of August, and that will cover non-patent IP. So it'll include an analysis of trademark, etc., copyright, and other patentable material, patents. Okay.